Okay. Welcome to the webinar today. My name is Christian Herpfer. I'm the president of WAPOR. And the talk of today is about the legal aspects of using AI in public opinion research. Our distinguished speaker today is Professor Stuart L. Pardau. Stuart is external counsel to WAPOR, APOR, and also to the Insights Association. He is an industry veteran providing legal support to the market research, analytics, and polling industries for over 2 decades. Stuart established his own law firm, Stuart L. Pardau Associates, in 2010, which is focusing on intellectual property, privacy and security, compliance, agreement negotiation, and drafting, among other areas. In addition, Stuart is an associate professor of professional practice at Miami Herbert Business School, focusing on the areas of law and technology. Prior to that, Stuart was chief counsel at G.D. Power Associates and was also formerly a tenured full professor at the Nazarian College of Business and Economics at California State University in Northridge. He's also a member of the Leadership Council of the Rand Corporation and the Institute for Civil Justice. Yes, so Stuart, the floor is yours. We are waiting for your impressive presentation. Thank you.
Christian, thank you so much for the kind introduction. I appreciate very much the opportunity to present before this body, WAPOR, an organization I've had the privilege of doing some legal work on behalf of and interacting with the various members. As Christian indicated, I've done and had again the fortunate opportunities to work closely with APOR and the Insights Association, and indeed ESOMAR. I've been involved over the years with presentations. So I'm delighted to have the opportunity to present on the subject of AI, but and that will be a central feature, but actually not only AI, just some general issues that we'll call adjacent to these developments that I think are going to be very important for um, small businesses, mid-sized businesses, large businesses, anybody who's interacting with some of these new technologies and in a very rapidly changing legal and regulatory environment. So we've got approximately 90 minutes together here. If we take the full time, that's fantastic. I'll be available for any questions for that period. But roughly speaking, let's plan on a presentation for approximately 50 minutes or so, the rest with questions. And feel free to present questions throughout my talking, and those can be relayed to me while I'm speaking by Yulia or others. Okay, so not a problem at all if you want to do that. All right, without further ado, let's begin. So the agenda, as Christian indicated, the main focus is AI and public opinion research and research generally, and specifically a lot of the intellectual property, give you kind of sense of the landscape, but talk about intellectual property protections, privacy and security, and some of the most relevant contract provisions for clients and vendors and other third parties you may be dealing with. And as I said, we have a significant amount of time for discussion, questions, answers, and so forth. I should note that even though I've done a tremendous amount of my focus as an attorney these past 20 plus years, I've been practicing law longer than that. But these past 20 or so years has been with market research and data analytics and political polling. That is not the sole focus of my client base or my work. But the kind of the areas I have focused on substantively that are kind of agnostic as to any particular industry is intellectual property, privacy, security. So if you have questions, concerns about those issues in any sort of way, I'd be again happy to drill down on those, and indeed will be the focus of this presentation. All right. We're all using artificial intelligence. Everybody is focused on it. Everybody is, if not integrating it into their business, certainly, playing around with it, so to speak, in trying different things out. And even if they're not doing those things, they feel maybe there's a pressure or some sort of indication to do so. Indeed, I was at a gathering last night and somebody is in a IT consulting and they're going in and they're just identifying opportunities within large corporations for AI utilization and integration because the pressure of senior leadership is simply so strong to uh, and for their shareholders because everybody's talking about it, everybody's focused on it to see how it can be adopted and incorporated. This creates, in my view, some other potential issues, and it touches on a theme that I'm going to be focusing on for much of this afternoon or this morning, wherever you may be. It's morning for me where I am, but it is going to be a focus because so much is about transparency and disclosure, and I'd say transparency is a key theme around AI, and it's certainly a key theme around the EU AI law, and the EU, no doubt, at this juncture at least, has probably the most significant and evolved area in that sphere, though that too is still new, just recently being adopted as of, or taking effect as of actually this calendar year. So, all right. So clearly, for researchers, for pollsters, we're talking about how we're integrating this technology, setting aside how we're presenting it and how we're trying to talk about it and integrate it in what we're trying to do, but in the actual design of the product, the design of the service. So think in terms of that as a major sort of starting point, right? Is how are we integrating it into our materials? How are we using it in maybe creating for survey side of the shop, drafting of questionnaires? How are we using it in analysis, assisting us in qualitative research? How are we using it to expedite quantitative research? Um, you know, Logic routing suggestions. How are we using it to assist us with localization and translation? It's all that and more. Then there's this idea of, not just in the design, but what it is actually like when it's put out in field in terms of fraud detection, helping with screening of duplications, quality scoring, sample optimization, and all of that. And then, of course, with, the analytical side, helping us code the open end, summarizing the findings, detecting anomalies, and other things. Now, clearly an emerging area, something that has been talked about now. Certainly, what I've seen stateside, and the focus of my work is in the United States, I should make that very clear, is the increasing use of synthetic data, so-called synthetic data. I think most people have an understanding for what that is or have heard that term. But let's just kind of level set. Let's agree on what that definition actually is for purposes of our discussion. And if you have a different understanding or you believe there's a different definition, that's fine. But just to kind of a sense of clarity and specificity, so we have a common understanding of the term as it's being used, at least today in this talk. So notionally, it's like, okay, you go out, you survey somebody, or you have a database. That is what we've certainly historically relied on for any sort of research. But there's this idea that, well, can we create a parallel uh, universe called synthetic data that's based on existing data? Because it would be certainly more cost effective. Almost, well, I shouldn't say certainly, maybe not at the beginning, but over time, we could see how that would certainly be very cost effective and scalable. And then we wouldn't have to deal with, some of these perhaps issues of personal privacy, maybe if we're using existing data, we're creating really, audiences and lookalikes. But what do we really do with it, right? I think it's a legitimate approach, potentially. The issue again comes around the transparency of its use, the disclosure that that data is in fact being used. I'll leave it to people a lot smarter than myself, and particularly people who are doing the actual research or the market research to determine the efficacy or potential efficacy of synthetic data. I'm just focused here and now on the regulatory and legal aspect of it. And what I'm saying is I'm seeing more of it. I think it's probably going to continue to be more visible. And to the extent it is, we come back to this magic principle, this magic, what I'll call the T word, transparency, key around synthetic data. If you take away anything from this talk today, remember this with respect to synthetic data, and frankly, with respect to a lot of the things we're going to talk about around AI, transparency is key. So if you are using it, be sure to have adequate disclosures in your agreements with, if you're a service provider to a client, if you're just an academic researcher, to clearly and plainly disclose that synthetic data was utilized with probably more than just that general statement, but to have a more of an elaboration, right, of the details around how it was obtained, how it was utilized, so people can assess on their own the efficacy of the inferences and conclusions drawn from said synthetic data. Last but not least, in the framework of AI's growing role in research, we see not just, frankly, in our industry, in our small little vertical here, but across the board, right? This idea and concern, legitimate concern of bias in the results generated, in the outputs generated from the AI, right? Because after all, it's a basic phenomenon. Those of us, shall we say, on the other side of 40 years old, maybe even the other side of 50, have understood this basic idea of garbage in and garbage out. This notion that if you have poor information, poor data points input, naturally the outcome is probably going to be similarly weak and garbage-like. So the same thing with AI, in the sense of if you're training off of models and content that is itself inherently biased, you're very possibly going to, or very likely going to get outputs. Now, the coders and all the people who are responsible for creating these LLMs will say, with I think some justification, they're acknowledging that they're trying to account for it, they're trying to wait for it, and we'll see what happens. But it's an ongoing issue, it's an ongoing risk, and it's something I think to be quite aware of. Same thing for hallucinations. What's a hallucination? For those of you that don't know, it's essentially when AI is just simply producing total garbage. And this has happened and been very embarrassing, with some embarrassing results for some. There were actually, in my country here in the US, some lawyers who thought it was a bright idea to use ChatGPT to produce a complaint in a lawsuit that was being filed. Looked very professional, looked very persuasive, looked very good. The problem was some of the cases and precedents cited in those materials didn't exist. So needless to say, they had a few issues with the court. So you have to be very careful in just assuming that everything that's going to be produced is reliable. It's not. There is bias. There is actually outright false information. That's a real risk you need to account for. There's questions and concerns of confidentiality, right? Are your utilizations of any of these large AI platforms, are your queries, are your inputs, are they strictly going to be kept confidential? I mean, if you're putting in very sensitive questions that you really need answers to, if you're doing some qualitative research or you're doing some other things, you're trying to find out about your company or more details and so forth, is that going to be kept confidential? And I think that remains an ongoing concern, an ongoing question. A lot, as we'll see later on in subsequent slides, does hinge on, obviously the platform that you're using, and specifically, are you using, the API service? What sort of program have you actually signed up for? And the legal terms are really what are going to inform the levels of confidentiality you can expect to have. And same goes for intellectual property ownership. Same goes for a lot of these other provisions. And be aware as well that as rapidly changing are the technologies, um, we are still in a situation as well where the legal terms are also going to be updated, privacy policies changed. So you have to stay current with this stuff. And that's about all I can say at the moment on that. All right. What's the global AI regulatory landscape? This is a very important and threshold question. It's an understandable question, but it's one that I think is still very, very early and still really clearly being formulated. The EU AI Act is, without question, probably the most comprehensive in the world, and that's not a surprise. The EU has typically been at the forefront of uh, regulatory regimes in the area of uh, privacy, certainly security. We saw this certainly with the GDPR and so forth. Same thing with the EU AI Act. That said, um, it's still taking effect this year. There's really not much that at least I'm aware of in terms of any significant enforcement actions. We will be clearly seeing those undoubtedly in the coming years, possibly even as early as 26, probably more likely into 27. Um, I again emphasize the T word, right? Transparency is key, and that's specific to the framework that's been set forth. And essentially, what the EU has done is segmented four different buckets, um, and they have identified what they call, high risk. Okay, that is sort of, you know, let's just say, people who are maybe making queries about how to build an atomic weapon or a dirty bomb or some sort of chemical weapons devices. Those are the sorts of things that obviously are going to be kept a very tight, we would hope, a very tight, uh, you know, set of standards and reviews and so forth in terms of regulating what the AI platforms can produce, how they can, maybe monitor more carefully the people who are making those queries, and so forth and so on. For the vast majority of what we're going to be doing, the collective we on this call, on this Zoom, in more broadly polling and research industries generally, I think, certainly we handle sensitive information, but nothing at that level. So we would probably be, there's four kind of buckets. My assessment is we would probably fall in that bottom bucket known as no risk, or perhaps somewhere around the minimal risk area. And for that, again, key attributes, at least for now: transparency, disclosure, right? That's really what we're talking about. I mean, if you're deploying for some reason a deep fake, I can't imagine necessarily a scenario where that would arise for us. But say that we were, and actually that did come up. I shouldn't be so quick to say no. It actually, and this is anecdotal, but in my country here in the United States, in the presidential election in 2024, there was a political, it was really a push poll. It wasn't a real poll for then President Biden. And it was a deep fake of Joe Biden telling people, actually stuff that wasn't true, he didn't say. That would be exactly the sort of conduct and activity that would be subject to some kind of sanction by a regulatory sort of regime, like the EU AI Act. The problem is the United States does not, as this second bullet notes, does not yet have any overarching AI law. So that is a problem, and most countries still actually do not. So I think in summation, I've listed a bunch of countries here. I don't need to go through all of them, but to varying degrees, I think people are still trying to figure it out, right? EU again seems to be the leader. Uh, the USA does not have anything. I don't think anything is anywhere near going to happen if I were to forecast the United States. Um, what is happening is sort of consistent with the regime we've seen for 20, 30 years in this area broadly of privacy and security, is more of a kind of a fragmented, a kind of more of a balkanized, sector specific or region-specific type of enforcement. So that doesn't mean that example of the deep fake I indicated would not be subject to some sort of a claim or regulatory intervention. I think it still could be, but it wouldn't be within the framework of some existing broad, this is the AI law that we're going to rely on. But I think it's just, again, coming back to these basic principles of disclosure, right? Transparency, and frankly, just good judgment and common sense, right? You shouldn't be using deep fakes, right? And if you are, for whatever reason, using it, make clear it's for what purpose, and make clear what it is and why. Um, it's just, again, about being clear and transparent. All right. Managing AI responsibly. I'm kind of alluding to this already, and I think you're catching my drift, so to speak, of what kind of the key theme here is: disclosure, transparency, um, and frankly, integrity is key. So more specifically, right? How do we get there? How do we manage AI responsibly? Well, some of you, I'm sure, are familiar. I know you're familiar with the ISO standards. There is the security standard that we do under research 27001. There's the standard for research. Well, lo and behold, there's an AI management system certification as well. ISO is not, in my humble estimation, is not the be all and end all. It's not perhaps in many areas as rigorous as one would like to see, but the fact is it is a standard, and it is a process that is being verified and reviewed by an independent outside third party. Does it have the rigor of a traditional, financial audit of a public company? Heavens no. That said, it's at least something. And I think anything we can do incrementally and additive is going to be helpful. Now, to date, have I seen any polling or research company avail themselves of these additional ISO audits other than sort of the traditional ones around security and privacy um, and research standards? I honestly haven't. But I will anticipate, and looking kind of forward, that we'll probably be seeing more and more of this. And then sort of, common sense sort of things. I mean, have a real system in place in terms of how you're using these tools. Keep an inventory of it. Make clear, which providers you're using, the versions you're using, be cognizant and mindful of the jurisdictions you're operating in. I mean, if you're, for example, operating a lot in China, and not to pick on China, but to just use that as an example, it's the second largest economy in the world, and it's still more so than most economies, I would say, more regulated and more controlled, certainly as it relates to things like flows of information. So these are the sort of things you're going to want to keep in mind. I think the other is, again, a common sense type of observation. Keep the human being involved, right? Keep the human in the loop for all critical research steps. Don't outsource everything to the AI. I think that is a recipe for disaster. It is something that is improving daily. It's a phenomenal thing that's occurring. Uh, it's historic, all of that, but without some sort of human involvement or human oversight, I think it is, as I said, a recipe for major problems. Document all your prompts, your outputs, and who actually has been reviewing all of those steps, meaning which person has been doing it. Again, this is a process, right? It's a process. Uh, Very different kind of process, but it has the commonalities as well to other processes that we've adopted and managed, and documentation is going to be very essential, not just um, from a litigation perspective, meaning in the United States, the tendency is to have private lawsuits. That's less the case, I'd say, outside. It's more maybe government regulatory intervention or enforcement or questioning. Again, if you have good documentation and you're cooperative with the regulators, that is going to be quite helpful. And then the final observation on that piece of documentation and document retention. And when I'm saying document retention, I mean around the steps you've taken and the processes you've maintained. That too is going to be enormously valuable if and when you have a client, as they increasingly do require, some form of a security audit, some form of a privacy audit, and whether there will be an independent audit known as an AI audit. Uh, I'm not yet seeing that. I'm not doubting that they don't already exist. But what I am saying is that will occur undoubtedly, whether it will be independently branded, if you will, as an AI audit or some sort of part of a security or privacy audit, or even frankly intellectual property audit. I don't know, but key takeaway is clients will be requiring you to have these records, and they will, as they often do, have what are known as audit provisions in their agreements requiring you to produce this information. AI and multilingual and multicultural research, again, this is a whole nother issue, and I'm happy to talk about that if there are questions. But I think you can appreciate the sort of issues that could arise. Um, the translations are not, I mean, they're amazing. Okay, let's put that out there. But that does not mean that they're going to be correct in every instance. That does not mean that you still will not be subject to some of the bias issues that we noted earlier. That does not mean you will not be subject to some of the hallucination issues we noted earlier. So yes, you can get pretty darn good machine translations, but you need some native review before deployment. Now, maybe we'll have this conversation again 5 years from now, 3 years from now, 8 years from now, and the technology will be so outstanding that this will be a moot point. I don't know. But what I'm saying is, for the time being, I urge you to have that native human review before deployment. You mentioned synthetic data. This is, again, an issue that I don't think is going away. I'd be very interested to hear if anyone is interested to share. Not necessarily right this moment, but at some point during our discussion today, your use to date of any synthetic data. But I see more of it. I see a lot of people talking about it. And I think the allure is almost inevitably uh, just too appealing from a cost perspective to just be dismissed. I mean, I think it's just there. And then I think there are other potential justifications I've heard. How valid they are, I don't know, but just around, you don't have to deal with, this fraud, in existing surveys. You don't have to deal with all of the back end cleaning issues you have to deal with in any sort of set of survey completes that have gone field. Um, Key again, I'm not here as the research expert. I'm here as the attorney, and as the attorney, I'm telling you, and you need, so in other words, you need to determine whether synthetic data works for you or not. All I'm saying is you need to be transparent and clear about this in the published results. And I think equally important, it's not just about, say you're producing some kind of a report, that's a syndicated report that's distributed to the public, say like a poll, a political poll. Most poll, not most, but many polls obviously are published and widely disseminated. It is there that you'd want to make that very clear, obviously, but not just in that situation, right? Meaning, it's not just what's communicated, say, publicly, it's what agreement you actually have with your particular client. If you've been retained by the Times of London to produce a poll, or the Guardian to produce a poll, and in conjunction with them, you're launching some sort of poll about some issue. You want to have, and you're using synthetic data or portions of it with synthetic data. You want to be real clear with your client, with the party that you're working with, that that is what you're doing. Because again, that can lead to major issues of failure to disclose, and you could run into breach of contract questions, or frankly, even worse issues. All right. So again, to recap, the do's and the don'ts. The do, you absolutely have to disclose AI usage to clients. The easy one is, if you're producing, um, a report that is written by AI, right? I mean, that's something you want to disclose. The harder ones get to be where on the margins you're using it, to what degree are you using it, to what extent are you using it, how much of is it integrated in the design of the study or the end product. These are these are the issues that have faced lawyers advising their clients for decades, for centuries, in terms of, it's not clearly A or B, right? This is where some further digging is required, further assessment, iteration, and then some reasonable conclusion, hopefully by whoever is advising you. Again, keep good logs. That's essential. Keeping good records, and validate certainly anything you're doing cross-cultural with translations, summaries, and the like. Some key don'ts. I think this should be obvious, but let's make it really super clear, right? Don't just throw personal information or personal data or personally identifiable information. It's basically all the same thing. We just use different phrases depending on which sort of jurisdiction we're in. Say in the EU, personal data. Just don't raw feed personal data into an AI platform, right? Hoping to get some sort of output, whatever that output might be, right? Because um, you're essentially sharing information with a third party. You don't know to what degree it's going to be confidential, even if it is contractually in the terms and conditions confidential. And I should note, and I will note more detailed in a moment, you're not going to be typically in a position to negotiate any legal terms with OpenAI or with Gemini, right? I mean, or Anthropic, or whoever you're using. I mean, obviously, right? So, so even if you do have what you think may be good, or your lawyer tells you are decent confidentiality provisions, you can't contract against data breaches, right? Data breaches can happen. There can be violations, and then again, that opens up a whole nother set of issues. So just don't do it. If you have to do it for whatever reason, again, give it very careful thought. See if there's other alternatives, and then proceed. Um, don't rely solely on those outputs without some human reviews. And then, you want to have some consistency in outcomes. So if you're using one tool and you're shifting midstream to another one, I mean, I think the client probably would like to know that, right? I mean, if it becomes, yeah, this is ever evolving. It's changing daily. But if one tool becomes known as being maybe more sort of biased in one area versus another, or stronger or weaker in another, again, if I'm the client, I would probably want to know what you use. And I should add the following, right? This is not new. Okay, this is not new, meaning AI is obviously new, but the principle of a client wanting to know what inputs you deployed, what vendors, what contractors you utilized, where the data has gone. Has it gone outside the borders of where it was collected, or the region in which it was collected? I mean, the EU as a whole, system around that, right? That's why we have the standard contractual clauses. You can't just transport personal data from the EU to North America. I mean, you can, but it's subject to all these requirements. So it's the same sort of thing, right? I mean, you're using these new and indeed revolutionary technologies. You should be applying at least that same standard we've kind of applied for a very long time, relating to other third parties who are utilized and particularly those third parties that are handling any sort of level of personal data or sensitive information. And I would add, particularly when that is got that cross-border element. All right. For the first 30 minutes or so, I've spent a lot of time on AI, which is appropriate. I spent a lot of time really um, on the privacy and the security side of the shop, right? And again, the T word, transparency. But let me talk about an issue that's very near and dear to my heart. I spent a lot of time on the intellectual property side of things. And this is, I think, maybe something that is a bit overlooked in market research and analytics and polling. So IP, what is IP? Short for intellectual property. It's a product of the mind, right? It's not a tangible. I mean, it results in can result in a tangible thing, of course, but the foundation is intangible. It's an intangible asset. And there's four major types, right? And this is pretty much across the board wherever you are on planet Earth, right? There's patents. I mean, there's going to be different requirements and different standards depending on what jurisdiction you're in, obviously. But the basic idea is there's patents, and we'll think of those as protecting inventions, okay? Um, in the sort of businesses and works that you're doing, patents are not as widely used as they were at one point. Um, but software, things of that nature still conceivably could be patented. Business methods, not as much or less so. But anyway, patents are a big area. Copyrights, copyrights, copyrights are a big area for what all of us are doing. Why? Because you're producing summaries, you're producing reports, you're producing analyses, uh, heck, even, your content on your website or a posting on social media. All of that would be a jingle that's created of some sort of, musical creation. All of that is subject to a photograph, a video, all of that is subject to copyright protection. So let's set that aside for one moment. But copyright's a big one. So you got patents, copyrights, the remaining two, trade secrets. I would say that's another potential huge area. It's sort of the back end secret sauce, behind the scenes, sort of processes, techniques that may not necessarily be delivered or are not actually delivered to a client, but are the engine of what makes whatever you're creating go. The key there is you have to keep those secrets secret, and you do so by having usually an NDA, a confidentiality agreement, something of that sort. And then trademarks are just sort of the name of the brand, of the company, of the service, of the product. I think for our purposes here, two ones I want to focus on are copyright and trade secrets. Okay. Those creations that are essential to producing whatever deliverables, whatever outputs are provided to a client, to a third party, frankly, to even the public at large, right? Right? So copyrights say the report that's created, the trade secrets, the underlying techniques, processes, know-how that may go into. So your cleaning specs, for example, could be subject to a trade secret protection. Your your weightings for your indices that produce certain rankings or uh, outputs, that too could be subject to potentially trade secret protection. Stuff like questionnaires, right? A questionnaire, a survey questionnaire, that is something that is absolutely protected in most cases by copyright protection. Your scripts, uh, if you have a panel asset, right, your database is potentially subject to copyright protection. So all of that stuff, it is essential you have it protected. How do you protect it? How do you protect it? You protect it the old-fashioned way, right? One way, and the old-fashioned way meaning through some contractual acknowledgement, let's call it, with the parties that you're dealing with. So it's clear to them that what you've created is yours. You own that sort of thing. Now, does that mean that, you have a copyright or a patent or whatever? No, it does not mean you have that ownership interest, but at least that other party is acknowledging that they do not have an interest in it. And for me, that is a really, really good start. You have to obviously then take independent steps to protect those underlying IPs. And that's something that's beyond the scope of this class or this webinar. You need to check within your own respective jurisdictions. If you're in Japan, or if you're in Germany, or if you're in Chile, or if you're in Egypt, you must check and see what are the requirements in my respective country to get those protections. But what I'm telling you is, as essential as that is, and I urge you to do that, essentially take an inventory. What do we have that could potentially be protectable? But the thing that can also, and is a necessary adjunct to that, is to have good contractual provisions with your clients, your vendors, any independent contractors, and the employees you have to ensure there is no conflation, there is no confusion, there is no misunderstanding about who owns what, about whose is whose. Again, sort of common sense sort of items. The AI element adds an additional layer of complexity when we're talking about what outputs are created through the AI. Now, I have not examined recently all of the terms and conditions of each of the major AI platforms. I have not done that recently, but at various periods I've looked at them. And I've more recently looked at OpenAI's for ChatGPT. It is pretty clear that under those terms, you, even in the publicly available one where you pay no fee, there's no subscription, you just, you Google OpenAI, you just go to OpenAI and you just, as I've done and do all the time, just make some general queries. There's no paid subscription there. And you have, as a result, a lower grade uh, set of protections, okay, legally. It's not as strong, not as good, but still, even with that low grade protection, you still have a clear assurance that those outputs you've created are owned by you, not OpenAI. So you can state, hey, those AI assisted outputs, no problemo, no worries, I own them. The issue is going to be to what sense and what level is all that work, all the inputs that went into it, which also you'll own too, by the way. Those inputs will clearly be yours. But to what degree will they be kept confidential? To what degree will those platforms be using to learn and to further enhance their own LLMs? Those are all potential open questions. What I would urge you to do is look at the respective terms and conditions of the platforms you will be using, and from that draw an assessment. Okay. My experience is, as it relates to at least OpenAI and ChatGPT, the paid subscriptions will get you a better set of legal terms, therefore perhaps making it worth it to pay the small fee for that purpose. All right. Then we get into these layers of subtlety and detail. You're producing an output, right? Unless you're doing what we call in the United States a syndicated study, that is a study that is just being published and it's just licensed like a subscription, like a Wall Street Journal or a Bloomberg or a Financial Times. Unless it's something like that, chances are, right, you're being retained by your client to produce a product, an output, if you will, that's owned by them, right? It's a work for what we call in the United States a work for hire. You're being hired to do the work. You're being paid. And naturally, the party paying you understands and expects that they own what you produce for them. So when I say here, client owns deliverables, that's a good rule of thumb, unless it's a subscription type of service. It's a it's a syndicated, what we'll call a syndicated report, and you're merely licensing the rights to access and use the materials, much like any sort of software license or SaaS, software as a service type product or service, I should say. Now, in this baseline situation where it's not a subscription, it's not syndicated, it's not SaaS, it's sort of what we'll call a more traditional custom research type project. Client owns the deliverables. Obviously, they have to pay you if it's a paid fee for service operation. But you still, as the supplier, should appropriately retain certain intellectual property rights around the tools you've used. And by the tools, I don't mean ChatGPT, but internal tools that you've developed, that you've created, that assist you in scaling and creating good and effective end products. The prompts, the inputs that are going into the AI, remember, who owns that? Not the AI company. You own that. So much is going to hinge, and there's been some really, really interesting, and it's not just anecdotal, this is already kind of academic, beginnings of academic research in this field of, who's going to be successful. There's all this discussion of, job elimination, as there's always going to be when there's a massive technology disruption, right? This is not new. I mean, AI could conceivably be at a whole nother level, absolutely, but it's the same sort of phenomenon of disruptive technologies. But the big question I think that we're all thinking about is, what does that mean for me personally? What does that mean for the sort of jobs we have? What does it mean for my kids, for my family? Those are all questions we're asking. There's already some academic research in terms of who's going to be most affected, who's going to be the most successful. I mean, there are obviously certain jobs that probably cannot be replaced by AI anytime soon, at least, electrician, plumber, jobs like that, right? So maybe there'll be a massive shift in emphasis and in demand for those sorts of jobs. We'll see. But the interesting research I've seen, and again, this is not anecdotal, this is actually, like research that some scholars have done, those who are going to be most effective is those who are really skilled at the prompts. Again, it comes into this garbage in, garbage out phenomenon. You could have access to the most amazing AI platform, the most amazing generative AI in the world, but if your prompts are not sufficiently clear or precise, and then you're unable to interpret that or understand those subtleties, it may not be as useful. So I think the people that are going to be able to successfully frame these prompts and master that, and then of course understand the implications once the output is delivered, those people are going to have a significant advantage. And what the research is kind of pointing to is that's going to even widen the gaps even further in terms of knowledge differences. So it's not necessarily good news, right? It may be good news for those of us who can be those individuals. But if it does play out that way, the conclusion, or at least the preliminary conclusion for some that I've seen, which was very interesting, and I'll locate that if you're interested. We can post it, which is basically saying those gaps are going to actually increase in terms of knowledge differences, and perhaps even we'll talk, think about income disparities and so forth. At any rate, all the more reason why you want to have control over the tools you're using as a supplier, over the prompts and that know-how and that knowledge that inures to that. That's going to be your superpower. That's going to be your secret sauce that's going to differentiate you from all the others. Now, what do you license to the client? Well, if it's a traditional market research, custom research type project, you're licensing the content to them, or excuse me, you're delivering the content to them. They own the content, right? It's a work for hire. They're hiring you to do the work. As a result, they're paying you, and guess what? They own it. But we're talking about the retention of these certain things that are ongoing and scalable and usable for all projects that aren't necessarily the reason you're being hired in terms of what the end product is, but it's that very knowledge, that very expertise is really the differentiator of why you're being deployed and why you're being retained, right? So sometimes you're required to license some of that as well to them, but that is only and should be narrowly tailored, not as, okay, here it is, here are all my prompts. No, no. You want to be very narrowly tailored. You want to be very guarded around those, in my view, and make clear that it only applies for and can only be utilized for the intended usages so that your client can actually use the deliverables that you originally contracted for, not for some other separate, independent purpose. Moral rights are a concept that do not exist in the United States. They exist in the EU, and I believe in some other jurisdictions. It's an interesting concept. As an American, it's one I've always struggled with, but it's outside the sort of legal framework, let's say. It's some sort of, artistic integrity, let's call it, that's protected. And I think that's admirable. I think that's laudable. I think it's well intentioned. I just don't know, wearing my American hat for a moment, if I may, how you can actually make that work, how that actually works in practice. But anyway, I point that out for those of you not in the United States. Moral rights has really not been something that's gained traction in the US. Could very well at some point in the future. But just note, coming back to the moral rights, it is something that is certainly, we see it, for example, in contracts all the time, when we're dealing with entities in the EU, for example, and also sometimes in Asia and other parts of the world. So just be aware that concept exists. What we do with it exactly is sometimes hard to assess. Um, Other things we can do to protect proprietary instruments. Remember, I talked about, what IP and intellectual property is for purposes of our talk here. Functionally, it's really probably just copyright and trade secrets, right? Copyright are the reports, the videos, the photographs, the you know, the summaries, the surveys, the invites, the abstracts, all that stuff. But there's also the processes, right? The back end stuff. And that's probably more, as I said, trade secret. And that's the stuff you want to guard real closely. I'm not aware. It may exist in your country. I suspect it doesn't. But I can tell you that in most countries, certainly in the United States, whereas copyrights or trademarks or patents you file with the government, you've got to actually apply in most cases, certainly for a patent. You don't for trade secrets. There is no avenue. There is no trade secret agency, okay, or trade secret government agency. It's all self-help, meaning you avail yourself of the trade secret protection through contracts, through processes, through security measures, through common sense steps. So common sense step one is don't give it to the world, right? Restrict, if you do distribute it, make it very finite. Restrict the distribution list, and certainly prohibit any distribution without permission. Okay? Second, document documents that you think are confidential and proprietary. Just label it. Will that itself be enough? Probably not. But will doing that assist you in protecting yourself and identifying it as confidential and proprietary later on if it ever becomes in dispute? Absolutely yes. Absolutely yes. So it's a small step. It's an easy step. It costs you nothing to label certain documents with the phrase confidential proprietary. The name of your firm is ABC, confidential proprietary information of ABC. That's it. That's all that you need. I can share with WAPOR after this call a little phrase that you can put in the footer of documents. Okay. Use NDAs. NDA, of course, is short for non-disclosure agreements. Use them routinely. You don't need a lawyer. Okay. You can do it yourself. There's very little that should change with an NDA. Sometimes you do get strange ones, that's true. But by and large, most NDAs have the same sort of provisions in them. If you have that, that is a contractual agreement and provision that will protect you if there is a dispute, and will in particular protect you if, for example, you have to share certain of your secrets, let's call it, certain of your very most precious pieces of processes, of techniques, of know-how that you're very, very protective of, but you need to say share it with a third party because that third party is a vendor, is a supplier, is a subcontractor, is somebody who is assisting you, who has been retained by you to produce a product or a service for a client. Give them a non-disclosure agreement. Give them a non-disclosure agreement. And again, keep good records. Now, let me pause and say one thing. This applies not just to NDAs. It applies not just to the subject matter of this talk today. It applies to any agreement that you ever enter into for your business, for your family, for whatever the purpose. So please, if you remember anything, remember this from today. Look in the contract. What is the governing law and where is the jurisdiction? Okay. What is the governing law and where is the jurisdiction? Because again, you could be in Algeria, and if you have a dispute with somebody in Mongolia, right? That's not an easy thing to navigate, right? You're on the other side of the, or much of the other side of the planet, very different societies, very different countries. How is that going to even work? How are you going to, in other words, be able to enforce that? Okay. It's a big question. We can't answer it all today, but be aware. Look at what the governing law is and where the jurisdiction is going to have where the, if a claim is ever brought, and have an idea of, okay, can I live with this? Maybe you can. I mean, if you're in Algeria and you've got to go to France, maybe it's not as far, maybe you feel it's close enough, whatever, right? Maybe it's culturally and laws are close enough, etc. Maybe that'll work, but maybe it won't. So you have to think about those situations, okay? Think in any contract, what is the governing law and where does it, the jurisdiction reside if there is a dispute? One other quick takeaway there is you can perhaps work a situation where you bypass the court system entirely and create a arbitration, a mandatory arbitration, right? Maybe in a neutral third country. That can be maybe an effective workaround if there's a dispute. But you still get into these enforcement issues because if the other party is not willing to play, is not willing to participate, then you still, unfortunately, are obliged to go to that person's country and try to enforce things. Unless they have assets and other things in your country, that may be another way to gain leverage. But it's a complex issue, but it occurs to me it's something we should definitely consider in looking at any of these agreements. I see that I'm now at the 1 hour mark. I will now quickly go through the rest of the slides, Yulia, and then I will stop and then be available for any questions. Um, Again, there are a bunch of training restrictions, right? Um, and you should just be aware of them, right? And you should note that this does not mean that you cannot train on client or respondent data. You might be able to, right? It just, you don't know if you can. There are other factors you need to consider before you do. So it's probably the prudent approach to assume that you cannot train on client and respondent data. Okay. And if it is permitted, it's typically going to be because it's a defined set of data sets, it's de-identified on personal, it's very clear on the specific purpose of that training, what the retention methods are, and usually will require destruction on the back end. Okay, this is a huge issue. I mean, there's a lot of huge issues today, and I've said that a few times, but this is another one. People think that content on a website is for the public. It's for the world, right? After all, it's the World Wide Web, isn't it? It's for the world. And yes, you can access the World Wide Web anywhere there's a decent internet connection. And it's a beautiful thing. It's helped bring the world together. I mean, it's created some bad things, obviously, but I think on balance, it's been good for humanity. At least that's my view. But that does not mean that it's yours for the taking. You can certainly, read the materials, but it's not behind a paywall, right? The issue is, remember what I talked about intellectual property. Intellectual property, IP for short. One of the areas is copyright. Copyright includes content on a website. The materials that are on a website are copyrightable. Doesn't mean it's all necessarily subject to copyright protection, but there's a very, very, very good chance that it is. So you can't just take somebody's stuff. If somebody posts what you think, oh, this is a really cool video, or you know what, this is a great picture that tells the exact story I want to utilize for my client. So I'm just going to copy and paste it onto my report, or worse, onto my syndicated report that's now going to be distributed to thousands of licensees across the globe. You have just created copyright, engaged in copyright infringement, and you are exposing yourself to claims. But here's where it really gets interesting. People think, well, the content certainly, why can't I just, write a program, have bots that crawl the web, and they'll just scrape all these websites. I'm going to get all this great information. I don't have to disclose this because I'm never going to publish it. I'm just using it for, my own purposes. No. No, that's not going to work. It's not going to work for several reasons. Not only do you have the intellectual property issue, you've got specific contractual terms and conditions on a website. Most of those terms, if they're written, and listen, not all websites have terms and conditions, but any website that is I'd say, an established website is likely to have terms and conditions. And I can pretty much assure you that those website provisions will specifically preclude web crawls, scraping, and the like. So you have just violated, congratulations, if you've done that, you've successfully violated those terms and conditions. So not only do you have a copyright infringement issue potentially, you have a breach of contract issue with that website. They can sue you. There's a third issue to be mindful of. Robots.txt. These are specific instructions. These are specific instructions that are given to Google and these other search engines, which basically say, do not allow crawls to happen. Or come on in. Everybody's welcome to my website. Come on in, take what you want. Or no, you can't access this information. Sophisticated websites know how to, it's like a switch that you could turn on or off. Sophisticated websites know how to utilize these tools. So that's another thing you need to look at is, what do the robots.txt instructions say for that specific site? Maybe there are very open-ended sort of things that you can deploy. So it's something else to potentially look at. For the EU, watch for the so-called sui generis, the sui generis database rights. This is again a sort of a new area. I'll put this in the moral rights type of category. No one really knows exactly fully what it means, but it's not stuff that you've created. It's more stuff that you've compiled. So there's some sort of rights that people may have in sort of the compilation of various materials. So again, new area, I just flagged that for you as a separate independent area outside of just ownership. Again, documentation is key. And it says avoid scraping for sensitive categories. I think more broadly, just avoid scraping entirely unless you've carefully examined the terms and conditions of that specific website. Key global privacy laws, GDPR, we're well aware of. That's still, I'd say, the biggest one. China has PIPL or PIPL. India has just adopted one finally after all these years, implementations pending. So, you get the feel, right? Things continue to grow. It's dynamic, it's ever changing. Just assume there's going to be more regulation, more enforcement activity over the coming years, not less. So better to get out in front of it. Again, you want a lawful basis, you want consent. That is key. Cross-border data transfers. This is again where we can get into issues. The EU in particular, and the UK not far behind. But the EU has what are known as standard contractual clauses, or SCCs, for transfers to countries that are deemed inadequate in their data protection and privacy protections. The EU has determined, and as an American, this is deeply hurtful. No, I'm joking. But it has determined America is not protective, okay, is not protective to an adequate level. Therefore, we don't qualify for the EU standards. Therefore, we are subject to the standard contractual clauses. So you're working in Europe, you're transferring personal data to North America. And by the way, that means even that the server, you're using AWS, and AWS's server is in North Dakota, right? That means you are falling within that set of rules. Okay, so you have to adopt the standard contractual clause. Good news is they're standard, right? You don't need a lawyer. You just you know go to the commissioner site, copy and paste, and boom, you have your SCCs. That's the good news. You don't need a lawyer. Bad news is you actually have to comply with what those terms actually say. So you've got to have a series of, standards to ensure that, it's adequately protected, and so forth and so on. I think there is where you probably do want to consult with somebody, at least on the security side, possibly even on the legal side, to ensure that, proper steps have been taken. A lot hinges as well on, what sort of data is actually being transferred, for what purpose, and so forth and so on. Here are a bunch of security baselines. Uh, there's all sorts of stuff that you can do, right? But I think the key thing for you to understand here in terms of the terminologies, the nomenclatures, there's this idea of privacy and there's this idea of security, right? As the lawyer, this focus today certainly has been on privacy, but there's a second distinct area that's clearly related called security. That's where you work with the information technology experts, right? And they can assist you with implementing additional security measures. Multi-factor authentication has been now pretty much a standard, right? I mean, it's annoying, it's infuriating at times, but it's for your protection, right? And it is a measure of additional security that existed, but it wasn't widely used, say, 5 years ago. Now it's been pretty widely adopted. Security folks will help you with that. Same thing with strong encryption standards, right? Then what we'll call vulnerability management, right? Conduct scheduled vulnerability scans, do penetration testing where somebody who you've hired pretends that they're a bad actor trying to infiltrate your system and then exfiltrate data. Hire people that will do that. If you have vendors, have service level agreements with your suppliers that if things occur that are security breaches or their performance problems, that you have security and SLA standards. Those are all critical. And then heaven forbid if there actually is a security breach, meaning someone's data has been violated, there's a whole slew of laws. EU 72 hours you have to report. US, it's got 50 states. It's a federal system. Unfortunately, each state has their own unique law. They're all kind of similar, but they all have their nuances. So it's a mess, frankly, if you ever have a data breach in the US. You want to immediately internally escalate it within your organization, identify whose data or the categories of data affected and which potential sources that data came from, because you'll need to alert those parties, right? Because they may be the original sources of it. It's a whole area of de-identification, right? This is a whole other thing, and because of time, I will probably not get into all these details, but here's the slide. Anonymization. There's something known as pseudo-anonymization, where full anonymization is not feasible, but you can replace the specific identifiers with pseudonyms, and you store the keys separately in some sort of encrypted storage. I mentioned incident responses. God forbid, if you ever have a security breach, you definitely need to follow these protocols. You have regulatory requirements and you'll have contractual requirements. Get in your statements of work all the essentials. If you're hiring someone to do work for you, hold them to standards, have an acceptance criteria. Don't just say, I'll pay you $50,000 US for this. No, you'll pay them only if you can reasonably accept it to the standards that you've contracted for. Define what those standards are in terms of quality, have review timelines, have correction cycles, and all the rest. DPAs, or data processing agreements, are now standard across the board. They're usually an exhibit, a schedule, an attachment to an existing services agreement. You've got, as I said, the standard contractual clauses. Those are certainly part of it. But independent of any EU connection, you're going to want a DPA, typically as a attachment or schedule to your services agreement. AI clauses, we're seeing them come up again and again and again, right? Either as an addendum to an existing agreement. You may have a long-standing relationship with a particular company or a client, and they'll say, hey, sign this addendum, sign this agreement. Why? Well, because of all this AI stuff happening, right? Very, very common. Don't be scared by it. It's increasingly common to see. We talked about the importance of intellectual property. Let me briefly note warranties and indemnities. These are three sort of, I'd say, key risk management features. Warranties are basically a statement of truth, right? We truthfully are stating that we honestly and truly comply with applicable laws and regulations. We are truthfully and honestly stating and representing to you that we will perform to professional standards. We are truthfully and honestly stating that we will maintain security controls. Those are the things you'll see in an agreement, warranties and representations. You want to get those from your vendors and from your suppliers, okay? Indemnity is essentially an insurance type of concept whereby you will agree if you're providing an indemnity, and conversely, you will receive, if you're receiving an indemnity, basically a guarantee of payment in the event certain things happen, right? In the event certain things happen. So for third-party claims, data breaches, and so forth. Last but not least, this is a key moment in this discussion, right? Why? Because it could save you a lot of money, and it could even perhaps save you your livelihood. Why? Because in theory, there's exposure of a financial amount that could be massive to your company in the event there's a problem or a breach, right? Um, for example, breaches in the EU are typically calculated on the basis of uh, a percentage of your worldwide revenue, sometimes 3% of your worldwide revenue, or 15 million euros or 13 million euros, whichever is greater. That could be a lot of money and a huge exposure to your firm. If you could somehow shift that burden to another party, that would be a good thing. So you want to try to not only effectively utilize indemnification as an insurance type of article, but also liability limits so that in your agreement with a party, they have agreed to limit any claim against you up to a certain amount of money. And that could be a very valuable thing. Usually the caps are expressed as a payment of the fees or a multiple of the payment of fees. Not uncommon to say, yes, we agree to that. However, these sorts of 2, 3 things not covered by the cap, usually IP infringements, certain regulatory fines, and then insurance, meaning actual third-party insurance, is always, always, always a good thing to consider. If you do not have insurance and you are a business and you're not working for a government agency or a research institution, but you're actually some kind of a business, and it's your business, you definitely should look into some form of insurance, whether it's professional liability insurance or cyber insurance. This is a final checklist. You want AI governance policies. Definitely look at those practices, assess what you need, make sure your IP is being protected. You want it through contract, and then assess your own country. What are the requirements to actually perfect that sort of protection, at least domestically? Have good privacy and security. Privacy, usually go to the lawyer. Security, you're going to go to the technology expert, the IT professional. Get good contracts in place for privacy and security stuff is going to be DPAs. And that concludes my talk. So that gives us about 15 minutes or so for any questions.
Thank you very much, Stuart. It was very interesting, a whole interesting world coming our way. Julia is the discussant. You can express send your questions or express your opinion three ways. Either you raise your hand, or you write in chat or in Q&A. So please either raise your hand or write in chat and Q&A, and hand over to Julia, who is chairing the Q&A session.
Thank you, Christian, and thank you, Stuart, for the very insightful presentation. I think everyone understood by now that using AI opens a Pandora box of legal risks. And we have a lot of people who are interested from all the parts of the world. I see people from about 50 participants today from the US, Canada, Brazil, Europe, Indonesia, Kenya, Kazakhstan, so many, many countries. And we have just 15 minutes left, so I invite colleagues to type the questions in the chat, and I start with the first one. So one big area which is regulated in survey research is using personal data and personal data protection. Now, how does this interact with this new emerging AI regulation? Say, I know that many colleagues using AI tools or developing elaborate AI tools to control the quality of research data or research responses to prevent falsification, for example. Now, do we have to ask an explicit consent from respondents anywhere to use any AI tools in quality control or analysis? Even if we don't sharing the personal data, maybe some sensitive data could be subject to that kind of regulation, and what kind of legal risks it creates. And also, what's the general trend of privacy, personal data protection regulation evolution in regard to AI?
Right. Those are very good questions. Let's start with the second one, right? Where are the trends? I think the trends are, to me, clearly headed towards further regulation. We're in a very, very still nascent or early stage. So, I mean, you think about, the splash, the first launch of public utilization for ChatGPT, that was sort of November, December of 22. About 3 years ago, almost exactly 3 years ago. Think about how different the world has become because of that, at least to those of us who are using it, and that pretty much describes all of us here. The laws haven't caught up, not even close. And that is not a phenomenon that I would say is unique to AI. That is a widespread situation overall with what I've studied over the years of technology and how the laws kind of just, fall behind or don't catch up. It was the same thing when in the 1990s when the internet became commercialized. I mean, it took several years before there was, at least in the United States, some codification, and then other reasons why it took a while to kind of play out. So to answer your question on that one, I think it's still very early on the regulatory side. The EU has adopted a standard, but that standard was just implemented this year. There's been no major enforcement action. Again, the EU is kind of at the forefront of this. There is no national AI law in the United States. And I think it's probably going to be a while, if I were to guess, before that happens. That does not mean that there won't be other types of things that will emerge and enforcement actions, but it's going to take a few years, I think, to play out. So in the meantime, the technology continues to grow. the technology continues to be adopted on a more widespread basis. So I see those gaps not getting smaller, but getting bigger. So that means for us, practically, we're operating in a zone of uncertainty in terms of how we navigate it. So even though there may not be necessarily clear direction, that does not mean that we're kind of open-ended to do whatever, we please with the technology. Because I think there will be incidents. I can't predict what those will be. None of us can, but that will likely precipitate some type of significant response in terms of, oh, we have to pass this law, or we've got to take this action, or we have to do this sort of thing. So it's not a very good answer to your question, because I think we don't know. But I think what we do know is the law is very far behind, and I just don't mean in the United States, I mean globally. The law is very far behind where the technology is. That's not unusual relative to other technologies that have been adopted in the past. But I think what makes this a bit different is how extensive, how significant, how disruptive AI is relative to all the other technologies which preceded it. So I think the stakes are so much higher this time. Um, so that's number one. In terms of the first question, um, so much, Yulia, is going to depend on how you're using the personal data. I mean, if you're using it, first, if you've collected it properly, forget AI for a moment. Let's say you've collected it properly. Let's say you're in the EU. You've gotten all the necessary disclosures. You've got all the necessary sort of things that are required under the GDPR. Question then becomes is, okay, you're using that personal data in some capacity with AI. But my question back to you would be, how? In what manner? Are you taking files and inputting it into ChatGPT? Are you, are you comparing it somehow or doing some internal analysis where there's really maybe no, query to chat? I mean, I would really want to understand how is it actually being integrated or used with the AI? It's going to hinge on that.
Thank you.
If I may use my position, I think there is always a time gap between social change, technology change, and how the law and how social sciences respond to it. We're always behind it. We are never the same time. So the question is the time lag. If it's a smaller thing like a change of some engine or so on, it doesn't hit so many people. If it's like artificial intelligence, it hits many people very quickly, like some sort of tsunami. So that's the problem we have. But the whole history of modernization, industrialization, we have this time lag. The lawyers, the parliaments, the legal scientists are never at the height of the time. They always need some time to understand, to respond, or to make laws, etc. And the social scientists, we need always about 10, 15 years to understand what happened in 68 or what happened in Woodstock and so on. We don't have an answer 6 months after that. So we are bound to be late. But your point is very good that we should not wait too long because it's a very encompassing wave coming our way, definitely. I think regarding polling, I do a lot of quantitative and qualitative research and so on. I think in quantitative research, it's not so easy, but in qualitative research, if you have lots of qualitative data, it's tempting to use AI, make sense out of it. You have all these elite interviews, you interview 20 politicians, and then you ask AI, tell me what is the outcome. So I think the temptation to use AI is much higher in qualitative methods than in quantitative methods, but maybe I'm wrong.
Yeah, no, that's a very, very good point. I mean, I think we're in total agreement that the technology is always going to outpace or almost always going to outpace the ability for parliamentarians, politicians, lawyers, lawmakers, rule makers, regulators to try to figure it out. So there's always going to be this lag. And in the meantime, the technology just keeps going as it, as it should. And I think it's almost, not only unrealistic, it just the wrong way of thinking about it to say, there's going to be an ability to regulate AI. I mean, you've got all these different nations. We don't have a world government, and I'm not sure we want to have a world government, but we don't, whether we like it or not. And there's no way to coordinate all these law. It's very, very difficult. I mean, we saw what's happened with climate accords and other attempts to regulate activities through worldwide trade and so forth. It's very complex. It's very difficult, and I think the technology is simply moving too quickly. So maybe tying back to even to Yulia's point is, you know, one of the key themes I've tried to emphasize in this talk was dynamic, ever-changing, still very thinly regulated, at least in terms of the AI. So what do? Well, transparency, right? Disclosure. I don't know if there's any great harm. Maybe there is. Maybe you would chill response rates if it's survey research. Maybe you'd scare away respondents. But and there's more of a question back to the group here. Is it going to chill response rate? Is it going to be a problem if you had some sort of, clear but nothing too scary, right? Of a disclosure that says, AI is a widely, utilized, technology. We, on occasion, may use it for various purposes, including without limitation, and list, 5, 6, 7 different things you might use it for, and just disclose it. And then the respondent can elect to say, yeah, I'm cool with that, I'm good with that, or not.
We probably, yeah, we probably start making notes on the website saying that this analysis might have been produced
Yeah.
with using AI, so we don't take the full responsibility.
Yeah, and I don't personally, I mean, I'm not in the business, right? I mean, I'm just advising, but it seems to me it's so widely used, particularly with younger cohorts, right? Are they going to even care? I mean, maybe some will. Some people are very sensitive to that stuff and may ask more questions. But I think with that, you may be covering yourselves legally in a way that maybe checks these basic boxes of disclosure, transparency, and you want to be truthful anyway. But I think so long as you're, again, if you're feeding, you know, Excel files into into some of these platforms with all this personal data, I'd say you may not want to do that. But that's not what I'm hearing, right? As most of the use cases. Most of the use cases I'm hearing are, well, I'm doing some qualitative research. I'd like to get some validation of my conclusions. I don't, I mean, I think, that's what it's there for.
Uh, that's one side. I'm looking at the chat. I do not see any questions in the chat or in the Q&A. So maybe if no more questions are coming, I just like to ask one more
Yeah, go for it.
point. One of the topics you raised in your presentation was about the ownership of the AI, any materials that is uploaded into the AI mechanisms. So if, again, we use AI for data quality control and
Right,
some data gets uploaded into the
right,
AI machine, uh, do we know if those algorithms currently do not misuse this
right,
data, do not reuse this data, that this
right.
data is duly protected and not don't get republished? Maybe you know specific cases like when
Yeah,
the leaks happened
yeah,
unexpectedly and that triggered
yeah.
some regulation.
Yeah, still, I think again, no major incidents that I'm aware of. That doesn't mean they haven't happened, but none that I'm aware of. But here's, I think, the takeaway on that question is the terms that I've reviewed, you would own it. I wouldn't worry about ownership. I think the issue is, will the AI platforms use that information to build and learn off of and train off of to enhance and build out their models, to build out the LLMs? That's the issue. And then will it be kept confidential? And even if it is, what happens when there's a data breach? Because they could take every step, they could be 100% honest, they could be 100% truthful, and they could say, yes, we're going to keep it confidential. Yes, we're not going to use it even to build are LLMs. Okay, but what if there's a data breach? It happens. What is the impact? There's nothing you can do. There's nothing you can do. The question would then be, you would have to then have a claim against the company for violating security or breaching confidentiality. But the damage at that point is done. So you'd have to assess, each of the respective terms and conditions. But generally speaking, Yulia, what I have seen is you will own the output. They will not display the output to other people, but they will use it to build and to learn and to train their models. Even if they don't, and again, if you have the API terms with OpenAI, they say in their terms they are not using it to train. Okay, so that's good. But my point is, even if everything they're saying is true, even if everything they're saying is 100% true, right? What if there's a data breach, right? So damage is going to happen. You'd have to bring a suit against them, maybe. Would you be successful? Who knows? But the point is the damage is already done. So I think you have to be careful of not uploading stuff that is either too sensitive or contains a lot of personal information. That would be my advice. I think that would be the prudent approach, because we're at the very early stages, okay, of this whole thing. I mean, right? So who knows what's going to happen? And just because these AI companies are saying they're doing things, I mean, call me cynical, but it doesn't mean they're actually doing it. Okay. I mean, that's
Understood.
that's my view. Yeah.
It sounds like we should repeat this webinar in a year or so to see
Oh,
what updates came up to date.
I'd be delighted to do it. I'd be delighted to do it. It's fun for me. I think about this stuff every day. So
Thank you, Stuart. Thank you, colleagues.
yeah,
We
thank you,
just at the
everybody.
end of our 90 minutes, so it's perfect timing.
Okay. Thank you very much.
Pleasure
Yeah.
meeting everybody. Have a
There
good
will
night.
be a recording on the website, and I'm sure Stuart can answer any questions on
And
email
Yeah.
we had 50,
if anything comes
55,
up.
55 participants.
Yeah.
Yeah.
Yeah, please feel free to post obviously the PowerPoint, and you have my email, or certainly Yulia or Christian, if you ever want to have a question, I'm happy to do it. And to the extent there's interest with you and the members, as I said, I'd be delighted to do this in a year, 6 months, or a year and a half, whatever works for you guys.
Great.
All
Thank you
right.
very much.
We'll see
Thank
Thank
you,
you.
you.
Alex.
Bye-bye. See
Bye-bye.
you.
Bye-bye.
Have a good day.
You too. Be well. Bye-bye.
Thank you.